Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Robbery Lawyers, Chicago, Illinois. Being accused of robbery in Chicago is a serious matter with potentially life-altering consequences. Illinois law treats theft-related robbery offenses as violent crimes, and a conviction can lead to significant prison time, steep fines, and a permanent criminal record that affects your future opportunities. These cases often hinge on complex facts, like whether force or the threat of force was actually used. As such, they require a careful, strategic defense. Working with an experienced Chicago robbery lawyer can make a critical difference in protecting your rights and building a strong case from the outset. Robbery Lawyers in Chicago, Illinois, serving all of Cook County. When you're facing a robbery charge in Chicago, you need more than just legal representation. You need a defense team that understands how Illinois law is applied in Cook County courts. At Combs Waterkotte, our attorneys bring a strategic, detail-oriented approach to every case, carefully analyzing the evidence, identifying weaknesses in the prosecution's claims, and building a defense tailored to your specific situation. We understand that no two cases are alike, and we treat every client with the focused attention their case deserves. Our firm has extensive experience handling serious felony charges, including robbery, armed robbery, and aggravated robbery. We know the stakes are high, and we are prepared to challenge key elements such as identification, alleged use of force, and witness credibility. From the initial investigation through trial, we work to protect your constitutional rights and pursue the most favorable outcome possible, whether that means negotiating a reduction in charges or fighting for an acquittal in court. Combs Waterkotte is committed to clear communication and accessibility throughout your case. We make sure you understand the charges you're facing, the potential penalties, and the legal options available to you at every stage. Our attorneys are responsive, thorough, and dedicated to keeping you informed so you can make confident decisions about your defense. With an office in Chicago and an established presence in Cook County, Combs Waterkotte is positioned to serve clients across the region. If you or a loved one has been accused of robbery, having a knowledgeable Chicago defense lawyer on your side can make a meaningful difference. Our team is ready to stand with you, advocate for your rights, and help you move forward. Just call 3-125-00-HELP to get started. What is robbery in Chicago, Illinois? Under Illinois law, there are several robbery-related offenses that cover stealing and theft. First and foremost is 720-ILCS5/18-1, a statute actually called robbery and aggravated robbery. That law defines robbery as taking property from someone else using either force or the threat of force. It's this force component that separates a serious robbery charge from a less serious theft offense. The same statute also defines aggravated robbery, an offense defined as robbing someone while indicating that they have a firearm, knife, club, axe, or other dangerous weapon, OR. Drugging a victim with a controlled substance via injection, inhalation, or ingestion, and then robbing them. It's important to note that an individual can be charged with aggravated robbery in Chicago even if they don't actually use or have a weapon on them during the robbery. Merely threatening the use or presence of a weapon is enough. A more serious weapon-related robbery offense, armed robbery, is defined under 720 ILCS 5/18-2. According to the statute, An individual may be charged with armed robbery in Chicago or Cook County when they commit a robbery and have a dangerous weapon on their person, have a firearm on their person, discharge a firearm during the robbery, shoot and either injure or kill a victim during the robbery. Finally, Illinois' Vehicular Hijacking Statute 720 ILCS 5/18-3 covers robbery offenses in which an individual steals a car. The law simply defines vehicular hijacking as taking a motor vehicle from someone else by force or the threat of force. The more serious aggravated vehicular hijacking law, 720 ILCS 5/18-4, covers more serious car thefts in which someone commits vehicular hijacking and the victim is 60 years old or older. The vehicle has a passenger under 16 years old. The perpetrator has a dangerous weapon on their person. The perpetrator has a firearm on their person. The perpetrator discharges a firearm during the hijacking, causing great bodily harm, permanent disability or disfigurement, or death. All of these robbery offenses maintain differing degrees of severity. As a result, penalties for robbery crimes in Chicago carry serious penalties under the Illinois Criminal Code. What are the penalties for robbery in Chicago, Illinois? Robbery offenses in Chicago and Cook County are always charged as felonies. They're even one of the few offenses that fall into the forcible felony category. This means a conviction for any Chicago robbery-related offense comes with the possibility of years or even decades in prison. The base charge for a standard robbery offense is a Class II felony. The charge may be elevated to a Class I felony, though if certain aggravating factors exist, like the robbery meets the threshold for aggravated robbery. The victim of the robbery is 60 years old or older. The victim of the robbery has a physical disability. The robbery occurs in a school, daycare, childcare facility, or place of worship. Armed robbery is even more serious. An armed robbery conviction in Chicago, Illinois, carries Class X felony penalties with possible sentencing enhancements based on the circumstances of the alleged incident, including an additional 15 years in prison for being armed with a firearm, an additional 20 years in prison for discharging a firearm during the offense, an additional 25 years to life in prison for shooting and injuring or killing a victim. Vehicular hijacking has similarly strict penalties. Standard vehicular hijacking is a Class I felony in Chicago, but aggravated vehicular hijacking is a Class X felony with weapon-related enhancements, including a 7-year mandatory minimum prison sentence for using a dangerous weapon, an additional 15 years in prison for being armed with a firearm, an additional 20 years in prison for discharging the firearm, an additional 25 years to life in prison for shooting and injuring or killing a victim. All of these additional prison sentences are added on top of any other prison sentences the court may impose. That's why it's critical to hire a criminal defense attorney with experience in Chicago and Cook County robbery cases to build a criminal defense strategy to fight your charges. Criminal defense strategies against Chicago, Illinois robbery charges. Hiring a criminal defense attorney to handle your Chicago robbery charges is one of the best things you can do. At Combs Waterkotte, we've helped Chicagoans in robbery cases before, and we've found the criminal defense strategies below to be helpful in securing acquittals, charge reductions, and dismissals. Alibi defense. An alibi defense argues that a defendant was somewhere else when an alleged robbery occurred, making it impossible for them to have committed the crime. In Chicago robbery cases, this often means presenting surveillance footage, phone location data, receipts, or witness testimony. Because robbery requires proof of presence and participation, a credible alibi can directly undermine the prosecution's case and create reasonable doubt about the defendant's involvement. Claim of right. A claim of right defense asserts that a defendant believed that they had a lawful right to the property they allegedly took. Since Chicago robbery charges require the intent to deprive someone of their property, this defense challenges that element. In Illinois, if a defendant genuinely believed the property belonged to them, the incident may not qualify as robbery, even if force was used, though it could still lead to other charges. Duress or coercion. Duress and coercion defenses apply when a defendant claims they were forced to participate in a robbery due to immediate threats of harm. Under Illinois law, this defense requires showing there was no reasonable opportunity to escape the situation. For example, if someone was threatened with serious injury unless they assisted in a robbery, this could negate criminal responsibility by demonstrating the act was not actually voluntary. Lack of intent. Robbery charges in Chicago and Cook County require a knowing, intentional act. A lack of intent defense argues that a defendant didn't have the mental state necessary to commit robbery. This may come up in situations involving misunderstandings, accidental conduct, or unclear ownership of property. By challenging whether a defendant intended to use force or permanently deprive someone of property, this strategy can weaken a key element of the prosecution's case. Self-defense or defense of others. In some situations, a defendant may argue that any use of force was justified as self-defense or defense of others. Illinois law allows individuals to use reasonable force to prevent imminent harm. If the alleged robbery occurred during a confrontation where a defendant was protecting themselves or another person, the focus shifts away from theft and toward justified conduct, potentially negating criminal liability, depending on the circumstances. Fourth Amendment violations. The Fourth Amendment protects against unlawful searches and seizures. In Chicago robbery cases, this defense challenges evidence obtained without a valid warrant or probable cause. If law enforcement violated constitutional rights by conducting an illegal stop or search, key evidence like stolen property or weapons may be suppressed. Without that evidence, prosecutors may struggle to prove the robbery charge beyond a reasonable doubt. Fifth Amendment and Miranda violations. Statements made by a defendant can play a major role in Chicago and Cook County robbery prosecutions. The Fifth Amendment protects against self-incrimination, and Miranda rights require police to inform individuals of their rights before interrogations. If Chicago police officers failed to advise a defendant of their rights or used coercive tactics, any resulting statements may be inadmissible in court, significantly weakening the prosecution's case. Mistaken identity and insufficient evidence. Robbery cases in Chicago typically rely on eyewitness identification, which can be unreliable. A mistaken identity defense challenges whether the defendant was correctly identified as the perpetrator. Factors like poor lighting or stress can lead to errors. By highlighting inconsistencies in witness testimony and gaps in the evidence, the defense can argue that the prosecution has not met its burden of proof. What to do if you're arrested for robbery in Chicago, Illinois? If you're arrested for robbery in Chicago or Cook County, there are several steps you can take to give yourself the best chance at beating your charges. The expert criminal defense attorneys at Combs Waterkotte suggest you do the following. Remain silent and do not answer police questions. If you are arrested for robbery in Chicago, one of the most important things you can do is remain silent. Anything you say can be used against you in court, even informal remarks made to police officers. You are not required to answer questions about the alleged incident, so clearly and politely state that you are invoking your right to remain silent, and wait until your attorney is present before speaking further. Request an attorney immediately. Asking for a criminal defense attorney as soon as possible is critical after a robbery arrest. Once you ask for a lawyer, law enforcement must stop questioning you. An experienced Illinois defense attorney can guide you through the process, protect your rights, and help you avoid making statements that could harm your case. Early legal intervention can significantly impact how your case is handled and potentially its outcome. Comply with law enforcement without resisting. Even though the situation may be stressful, it is essential to remain calm and avoid resisting arrest. Resisting or obstructing officers can lead to additional criminal charges and complicate your situation. Comply with lawful orders while still asserting your rights verbally, such as requesting an attorney or declining to answer questions. Staying composed can help prevent escalation and protect your legal position. Do not consent to searches. Police may ask for permission to search your person, vehicle, or property when you're charged with robbery in Chicago. You have the right to refuse these search requests if police do not have a warrant or probable cause. Consenting to a search can make it easier for law enforcement to gather evidence against you. Politely but clearly state that you do not consent. If officers proceed without a warrant or legal justification, your attorney may later challenge the admissibility of any evidence obtained. Document everything you remember. As soon as you can, write down everything you remember about your arrest and the events leading up to it. Include details like the time, location, officers involved, and any witnesses. Memories can fade quickly, and having a clear record can be valuable for your defense attorney. This information may help identify inconsistencies in the prosecution's case or support potential legal challenges. Attend all court dates and follow conditions of release. After being released, you must attend all scheduled court appearances and comply with any bond conditions set by Cook County Court. Missing a court date can result in a warrant for your arrest and additional legal consequences. Following all requirements demonstrates responsibility and can positively influence how the court views your case as it progresses through the Chicago legal system. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.